Okay, so today I'm going to be looking at the final reports on the investigations into Hunter Biden and Donald Trump for the January 6th stuff, and then for Hunter Biden for I think it's the gun crime that the special prosecution, special counsel is charging him for. So, we're going to start with Hunter Biden because you gotta have your veggies before you can have your dessert. So, yeah, I guess might as well start with his letter to the Attorney General. So, January 10th, 2025. Dear Attorney General Garland, referring to Merrick Garland, the Attorney General of the United States, head of the DOJ. You appointed me special counsel on August 11th, 2023. Pursuant to the appointment order, you charged me with continuing my investigation into, quote, allegations of certain criminal conduct by, among others, Robert Hunter Biden, end quote. The special counsel regulations require me, at the conclusion of my work, to, quote, provide the Attorney General with a confidential report explaining the prosecution or declination decisions reached, end quote. My final report is enclosed. As special counsel, I prosecuted Hunter Biden in 2 cases and obtained convictions in both. In one case, Mr. Biden pleaded guilty to all counts. In the other, a jury found him guilty of all counts. In my report, I discuss the prosecution decisions that led to the 2 charged cases and subsequent convictions. On December 1st, 2024, before Mr. Biden could be sentenced in either case, President Biden pardoned his son for all criminal offenses he committed or may have committed over the last 11 years. In light of this pardon, I cannot make any additional charging decisions as to Mr. Biden's conduct during those 11 years. It would thus be inappropriate to discuss whether additional charges are warranted. The special counsel regulations also provide that the, quote, Attorney General may determine that public release of these reports would be in the public interest to the extent that release would comply with applicable legal restrictions. All other releases of information by any Department of Justice employee, including the special counsel and staff, concerning matters handled by special counsels, shall be governed by the generally applicable departmental guidelines concerning public comment with respect to any criminal investigation and relevant law, end quote. When appointing me special counsel, you state that you are, quote, committed to making as much of my report public as possible, consistent with legal requirements and department policy, end quote. Therefore, in drafting this report, I was mindful of department policies that caution restraint when publicly revealing information about uncharged third parties, specifically with respect to, quote, public filings and proceedings, end quote. Justice Manuel, subsection 9-27-760, provides that prosecutors, quote, should remain sensitive to the privacy and reputation interests of uncharged parties, end quote, and that it is generally, quote, not appropriate to identify a party unless that party has been publicly charged with the misconduct at issue, end quote. The Justice Manual also sets forth factors to guide the disclosure of information about uncharged individuals, such as their privacy, safety, and reputational interest, the potential effect of any statement on ongoing criminal investigations or prosecutions, whether public disclosure may advance significant law enforcement interests, and other legitimate and compelling governmental interests. Based on these policies, as well as my obligation to abide by them, this report does not discuss the conduct of uncharged third parties, because I publicly charged former FBI informant Alexander Smirnov for obstruction and lying to federal agents about Mr. Biden and his father, as well as for tax offenses. The report mentions him by name. Otherwise, the report focuses only on my charging decisions as to Mr. Biden. It has been my pleasure to serve as special counsel for the last 17 months alongside my small team of dedicated Department of Justice employees. Thank you for allowing my office to conduct its investigations and prosecutions independently. Sincerely, David C. Weiss, Special Counsel. Okay, and now? Report on the investigation into the criminal conduct of Robert Hunter Biden, Special Counsel David C. Weiss, submitted pursuant to 28 CFR subsection 600.8c, Wilmington, DE, January 2025. Table of contents. Okay. 1. Introduction. On August 11, 2023, Attorney General Merrick B. Garland appointed me as special counsel. My charge was to complete the investigation into, quote, allegations of certain criminal conduct by, among others, Robert Hunter Biden, end quote. In the last 17 months, I have obtained convictions in 2 separate cases against Mr. Biden for tax crimes and firearms offenses. I have also obtained convictions in 2 additional cases against Alexander Smirnov, who lied to government agents about Mr. Biden and President Joseph R. Biden and committed tax crimes. I am a federal prosecutor. I've served my country at the U.S. Department of Justice for over 20 years, first as a line prosecutor, then as a supervising prosecutor, and finally as the United States Attorney for the District of Delaware. Throughout my career, I have endeavored to apply the well-established standards for the prosecution of criminal offenses to the facts as I found them. I have followed the evidence and held accountable those who violate the law, and most significantly, I have always done my best to uphold the fundamental values of fairness and justice. These values are reflected in the principles of federal prosecution, which are some of the most important rules in the federal criminal justice system. Under the principles, the United States should recommend prosecution if, quote, the person's conduct constitutes a federal offense, end quote. End quote, the admissible evidence will probably be sufficient to obtain and sustain a conviction, unless 1. The prosecution would serve no substantial federal interest, 2. The person is subject to effective prosecution in another jurisdiction, or 3. There exists an adequate non-criminal alternative to prosecution, end quote. I have looked at the principles to guide my decision-making throughout my career. I prosecuted the 2 cases against Mr. Biden because he broke the law. A unanimous jury who found Mr. Biden guilty of gun charges and Mr. Biden himself, who pleaded guilty to tax offenses, agreed. As I have done for 20 years, I applied the principles of federal prosecution and determined that prosecution was warranted. My decisions to charge those crimes were based not only upon the Constitution's requirement of probable cause, that is, quote, reasonable ground for belief of guilt, end quote, but also the principle's additional requirements that, quote, the person's conduct constitutes a federal offense, end quote, that, quote, the admissible evidence will probably be sufficient to obtain and sustain a conviction, end quote, and that the prosecution, quote, serve a substantial federal interest, end quote. The successful results obtained in these cases provide confirmation that these requirements were met. On December 1st, 2024, days before Mr. Biden was scheduled to be sentenced for his crimes, President Biden signed a full and unconditional pardon for his son, covering nearly 11 years of conduct, including conduct related to both of the convictions I obtained during my time as special counsel. The pardon also encompasses uncharged conduct over those 11 years, and when he announced the pardon, President Biden simultaneously issued a press release to criticize the prosecution of his son as, quote, selective, unfair, infected by raw politics, and a miscarriage of justice, end quote. This statement is gratuitous and wrong. Other presidents have pardoned family members, but in doing so, none have taken the occasion as an opportunity to malign the public servants at the Department of Justice based solely on false accusations. As Judge Mark C. Scarzi, the judge presiding over Mr. Biden's tax case, stated, the Constitution provides the President with broad authority to grant reprieves and pardons for offenses against the United States, U.S. Court. U.S. Constitution, Article 2, Subsection 2, Clause 1, but no way does the Constitution give the President the authority to rewrite history. These prosecutions were the culmination of thorough, impartial investigations, not partisan politics. 8 judges across numerous courts have rejected claims that they were the result of selective or vindictive motives. Calling those rulings into question and injecting partisanship into the independent administration of the law undermines the very foundation of what makes America's justice system fair and equitable. It erodes public confidence in an institution that is essential to preserving the rule of law. In prosecuting these cases, I exercised my best judgment in deciding whether we could prove the cases and whether there was a substantial federal interest. I recognize that reasonable minds may differ about the correctness of my decisions. What should not be questioned, however, is that these decisions were duly considered and made in good faith with fidelity to the principles of federal prosecution. Far from selective, these prosecutions were the embodiment of the equal application of justice. No matter who you are or what your last name is, you are subject to the same laws as everyone else in the United States. So, basically that was summarizing his job, what he did, the effects of that, and the responses. I disagree that this wasn't because of politics. I think that it was because Hunter was a Biden, and that If Hunter hadn't been a Biden or related to the president, this wouldn't have happened. The whole House Republicans investigation and all that stuff, all the hearings into bogus claims about Burisma and stuff like that, is what kicked all this stuff off, into the Hunter Biden laptop and stuff like that. The false claims from Smirnov, which he prosecutes in this indictment or report, is what kicked this off, and all this false stuff, all because Hunter was a Biden. He was the president's son. It's hard to say that most people who may or may not have done drugs while possessing a firearm, or while they applied for a firearm, based on very limited evidence, would have gotten the federal treatment that Hunter did. But I guess there's no reason to complain anyway, since he's pardoned. Okay. 2. Principles of federal prosecution. My prosecution decisions were guided, as they have always been, by the long-standing principles of federal prosecution, which are memorialized in the Department's Justice Manual. They serve as the fundamental framework used to reach the judgments described in this report. The principles constrain the prosecutor's substantial power by limiting it to those cases that present real, provable, and blameworthy criminal conduct. They guide prosecutors in exercising their all-important discretion, in Attorney General Jackson's words, quote, to select the cases for prosecution and to select those in which the offense is the most flagrant, the public harm the greatest, and the proof the most certain, end quote. The threshold requirement for a federal prosecution is probable cause. Probable cause is, quote, a reasonable ground for belief of guilt, end quote. While the Constitution requires probable cause for every prosecution, the principles of federal prosecution require more. A prosecutor must reach 2 conclusions in every case before charges may be brought. 1, that the person's conduct constitutes a federal offense, and 2, that the admissible evidence will probably be sufficient to obtain and sustain a conviction. Under the first requirement, the prosecutor must conclude that the person is in fact guilty. Under the second requirement, a prosecutor must conclude, quote, that the person will more likely than not be found guilty, beyond reasonable doubt by an unbiased trier of fact, and that the conviction will be upheld on appeal, end quote. The second inquiry focuses on a jury's consideration of the admissible evidence and the legal instructions. Even when a prosecutor determines that the person has committed a federal offense and that the evidence is sufficient to obtain a conviction, the principles require that he also assess whether 3 other factors exist that may counsel against prosecution. 1, the prosecution would serve no substantial federal interest. 2, the person is subject to effective prosecution in another jurisdiction. Or 3, there exists an adequate, non-criminal alternative to prosecution. Several sections of the principles are devoted to the complex considerations of making these judgments. As relevant here, the principles state that, in determining whether prosecution would serve as a substantial federal interest, the prosecutor should, quote, weigh all relevant considerations, end quote, including 1, federal law enforcement priorities, including any federal law enforcement initiatives or operations aimed at accomplishing those priorities. 2, the nature and seriousness of the offense. 3, the deterrent effect of prosecution. 4, the person's culpability in connection with the offense. 5, the person's history with respect to criminal activity. 6, the person's willingness to cooperate in the investigation or prosecution of others. 7, the person's personal circumstances. 8, the interest of any victims. And 9, the probable sentence or other consequences if the person is convicted. Therefore, in making my choice decisions, I concluded that Mr. Biden had committed each and every one of the elements of a criminal offense. I determined not only that he had committed federal offenses, but also that a faithful jury would be more likely to convict than acquit him. That no other factors, individually or collectively, counseled against prosecution. At no time did my decisions take into account personal opinions, mine or anyone else's, about Mr. Biden's moral character, his popularity or unpopularity among the general public or a certain subgroup, like a political party, the ethical propriety of his conduct, or other value judgments that are not embodied in the elements of the criminal offenses themselves. I also never considered whether my decisions will be viewed favorably or unfavorably by any politicians, and when the politicians expressed opinions about my conduct, I ignored them because they were irrelevant. Simply put, my decisions were based on the facts of the law and nothing else. So this is basically explaining what he needed to get the indictment and for the charges and stuff. He had to overview all this stuff and determine, yes, this is true, and that's why I'm going to indict him. So, I guess we should look at these considerations that he'd weigh. Federal law enforcement priorities, including any federal law enforcement initiatives or operations aimed at accomplishing those priorities. I mean, I guess enforcing the law, so I guess, yeah. The nature and seriousness of the offense. Lying on a gun form about drug use. And then tax filings that were paid back. The deterrent effect of prosecution. I don't think there'll be much deterrent. I don't think Hunter's done anything recent like that. The person's culpability in connection with the offense. Obviously, he's the one doing it. Person's history with respect to criminal activity. If you're talking about charged activity, I don't know if there's any. But if you're talking about uncharged, like drug use and stuff like that, I guess you could say that. The person's willingness to cooperate in the investigation or prosecution of others. There were no others to prosecute. But I think Hunter cooperated. The person's personal circumstances, don't think that affected anything. Interest of any victims, don't think there was any. Probable sentence or other consequences if the person is convicted, don't think there was any. So I guess decent by the decisions. Okay, charging decisions. As United States Attorney, and then as Special Counsel, I supervise investigations of various offenses that may have been committed by Mr. Biden, including tax and firearm offenses. The tax investigation revealed that Mr. Biden engaged in a 4-year scheme not to pay at least $1.4 million in federal taxes he owed for tax years 2016 through 2019, and that he evaded taxes for tax year 2018 when he filed a false return for that year in 2020. More specifically, between 2016 and 2020, Mr. Biden received more than $7 million in income. Instead of paying his taxes, he chose to spend the money on his extravagant lifestyle, including drugs, escorts, luxury hotels, and exotic cars. And when he did finally pay some of his taxes, he falsely claimed that personal items, including clothing and escort services, were business expenses. The evidence also showed that Mr. Biden's conduct giving rise to the false return and tax evasion charges largely occurred in 2020, the year after he stopped using drugs and alcohol. Investigators also learned that, in October 2018, Mr. Biden lied on a federal background check form when he pursued a revolver, a Colt Cobra 38 SPL. When buying the gun, he purchased a speed loader and 25 cartridges of hollow point ammunition, a type of bullet that expands upon impact and causes significant lethal damage. He then completed an ATF form 4473, and answered no to a question that asked, quote, are you an unlawful user or addicted to any stimulant, narcotic, drug, or any other controlled substance, end quote. The form 4473 also required Mr. Biden to certify those answers were true, correct, and complete. Mr. Biden eventually left the gun unsecured in his unlocked truck alongside crack cocaine on someone else's property where children lived. Upon finding the firearm and without telling Mr. Biden, his girlfriend threw it in a trash can at a nearby supermarket where it was found by an elderly man searching for recyclables. That's a weird situation, I guess. In 2021, while the investigation was ongoing, Mr. Biden published a memoir, Beautiful Things. In the memoir, Mr. Biden admitted to smoking crack, quote, every 15 minutes, 7 days a week, end quote. In 2018, the same time period during which he possessed the firearm and lied in the federal forms. Ultimately, for the reasons set forth below, I conclude that the principles of federal prosecution were satisfied as to both the tax offenses and the gun offenses. A. The principles of federal prosecution supported bringing tax charges against Mr. Biden. Based on the evidence gathered during the tax investigation, I conclude that Mr. Biden's conduct constituted a federal offense. Specifically, he violated 26 U.S.C. subsection 7201, which criminalizes willfully attempting to evade or defeat taxes, 26 U.S.C. subsection 7203, which criminalizes willfully failing to file and pay taxes, and 26 U.S.C. subsection 7206, which criminalizes willfully filing a false tax return. I also determined that the admissible evidence indicated that conviction was likely. Pursuant to the principles, I then evaluated the following factors to determine whether the prosecution, quote, would serve no substantial federal interest, end quote. For the reasons explained, these factors weighed in favor of prosecution. First, I consider the nature and seriousness of Mr. Biden's conduct with respect to his taxes. As a well-educated lawyer and businessman, Mr. Biden consciously and willfully chose not to pay at least $1.4 million in taxes over a 4-year period. From 2016 to 2020, Mr. Biden received more than $7 million in total gross income, including approximately $1.5 million in 2016, $2.3 million in 2017, $2.1 million in 2018, $1 million in 2019, and $188,000 from January through October 15, 2020. In addition, in 2020, Mr. Biden received approximately $1.2 million in financial support from a personal friend. Mr. Biden made this money by using his last name and connections to secure lucrative business opportunities, such as a board seat at Ukrainian industrial conglomerate Burisma Holdings Limited and a joint venture with individuals associated with the Chinese energy conglomerate. He negotiated and executed contracts and agreements that paid him millions of dollars for limited work. Despite this, and in furtherance of this multi-year scheme not to pay taxes on this income, Mr. Biden subverted the payroll and tax withholding process of his own company, Owasco PC, by withdrawing millions from Owasco PC outside of the payroll and tax withholding process that was designed to perform. Spent millions of dollars on an extravagant lifestyle rather than paying his tax bills. In 2018, stopped paying his outstanding and overdue taxes for tax year 2015. Willfully failed to pay his 2016, 17, 18, and 19 taxes on time, despite having access to funds to pay some or all of these taxes. Willfully failed to file his 2017 and 18 tax returns on time, and when he finally did file his 2018 returns in 2020, reported false business deductions, including approximately $388,000 for purported business travel in order to evade assessment of taxes and to reduce the substantial tax liabilities he faced. These are not inconsequential or technical tax code violations, nor can Mr. Biden's conduct be explained away by his drug use. Most glaringly, Mr. Biden filed his false 2018 return in which he deliberately underreported his income to lower his tax liability in February 2020, approximately 8 months after he regained his sobriety. Therefore, the prosecution of Mr. Biden was warranted given the nature and seriousness of his tax crimes. Second, I consider the deterrent effect of any prosecution of Mr. Biden for his tax offenses. The Justice Department's criminal tax manual states that general deterrence is a, quote, primary consideration, end quote, in criminal prosecutions for violations of the tax code. The tax manual further provides that, quote, civil remedies generally are an adequate alternative for deliberate and significant tax fraud. The prospect of the criminal conviction and the imposition of jail time are necessary to deter tax crime and punish tax criminals in order to preserve the integrity of the nation's self-assessment tax system, end quote. The evidence showed that during the relevant time period, Mr. Biden had the money to pay his outstanding tax liabilities, but chose to spend that money on personal expenses. Moreover, Mr. Biden failed to timely file and pay his taxes over a 4-year period, and then, after becoming sober, he chose to file false returns to evade payment of taxes he owed. I conclude that the prospect of criminal penalties was necessary to accomplish the goals of both specific and general deterrence in this case. Third, I examined Mr. Biden's culpability in connections with his offenses. Mr. Biden had no co-conspirators. The evidence demonstrated that as Mr. Biden held high-paying positions earning him millions of dollars, he chose to keep funding his extravagant lifestyle instead of paying his taxes. He then chose to lie to his accountants and claim false business deductions when, in fact, he knew they were personal expenses. He did this on his own, and his tax return preparers relied on him, because, among other reasons, only he understood the true nature of his deductions, and he failed to give them records that might have revealed that the deductions were bogus. Furthermore, Mr. Biden never disclosed to his tax return preparers that he was using drugs during the years in question, something that might have caused them to more closely examine his representations that he had incurred significant business expenses, and his returns were prepared and filed before he published his memoir discussing his drug addiction. Fourth, I considered federal law enforcement priorities with respect to tax enforcement. The tax memo makes clear that criminal enforcement of the tax code is a high priority. Against these factors, I weigh Mr. Biden's criminal history, as is often the case in tax prosecutions. Mr. Biden did not have a criminal history, although I was aware that he had committed gun offenses. I consider his struggles with addiction and his choice to file false returns after he became sober. I also consider that he violated tax laws over a period of several years, and he therefore had a pattern of misconduct related to his taxes. While Mr. Biden had a personal friend who paid a large portion of his outstanding tax liability in 2021, after Mr. Biden knew he was under investigation, I recognize that this was likely inadmissible evidence at trial, and that it did not materially mitigate Mr. Biden's culpability. And although Mr. Biden may have entered into a loan agreement with a personal friend who paid his taxes, there is no evidence that Mr. Biden repaid any of those funds. Accordingly, I conclude that these factors weighed in favor of prosecuting Mr. Biden for his tax offenses. B. The principles of federal prosecution support bringing gun charges against Mr. Biden. So, I don't mind the tax stuff as much as the gun charges. But I don't know if federal prosecution was. I feel like it could have just done state, and that'd be more than enough. But how about B? The principles of federal prosecution support bringing gun charges against Mr. Biden. I determined that Mr. Biden's conduct with respect to his possession of a firearm violated 18 U.S.C. subsection 922 G3, which criminalizes possessing a firearm when addicted to or using a controlled substance, 18 U.S.C. subsection 922 A6, which criminalizes making a false statement on a federal form in connection with a firearm purchase, and 18 U.S.C. subsection 924 A1A, which criminalizes making a false statement related to information required to be kept by a federally licensed firearms dealer. Based on the admissible evidence, I conclude that there will be a high likelihood of conviction. In particular, subsection 922G3 offenses can be challenging to prove because prosecutors often do not have sufficient evidence to show that a defendant is an, quote, unlawful user of or addicted to, end quote, a controlled substance at the time in question. Here, Mr. Biden published a memoir, Beautiful Things, in which he admitted to his extensive crack cocaine use and addiction during the same time period when he possessed a firearm. The publication of the memoir significantly alleviated the issue of proof in this case. I again assessed the factors set forth in the principles of federal prosecution to determine whether prosecution would, quote, serve no substantial federal interest, end quote. Like with the tax offenses, I ultimately conclude that these factors weighed in favor of prosecution. First, I consider the, quote, federal law enforcement priorities, including any federal law enforcement initiatives or operations aimed at accomplishing those priorities, end quote. Prosecuting firearms offenses has been a top priority for the federal government for many years. For example, in June 2022, President Biden signed the Bipartisan Safer Communities Act, which was enacted to reduce gun violence and strengthen firearms enforcement. Ooh, using Biden's own laws. Okay. Among other things, the statute increased the maximum penalty for a 922G3 offense from 10 to 15 years imprisonment. Jeez. Got some sense on this. Moreover, pursuant to the Act in 2023, the Bureau of Alcohol, Tobacco, Firearms, and Explosives proposed a rule designed, quote, to reduce the number of guns sold without background checks and keep guns out of the hands of criminals, end quote, by increasing the number of transactions requiring background checks. Second, I consider the nature and seriousness of Mr. Biden's gun offenses. At a time in his life when he was regularly engaging in illicit drug deals to purchase crack cocaine, Mr. Biden lied on federal background check forms and illegally bought a revolver, a speed loader, and hollow point bullets. Mr. Biden admitted in his memoir that during that time period he was, quote, dependent not only on criminal subculture to access what you need, but the lowest rung of that subculture, the one with the highest probability of violence and depravity, end quote. Mr. Biden also described an episode when he had a gun, quote, gun pointed at his face, end quote. Further, after Mr. Biden bought the revolver in October 2018, he carelessly left it unsecured at a property where children lived and in a vehicle that also contained crack cocaine and drug paraphernalia. The fact that Mr. Biden's girlfriend tried to dispose of his firearm before violence resulted does not make his crimes any less serious. As to the specific gun offenses with which Mr. Biden was charged, an analysis of Justice Department data from 2008 to 2017 shows that G's charges are brought more frequently than over 90% of the other available firearm offenses. Out of the 86 different types of federal gun charges listed in that study, the gun charges filed against Mr. Biden are the 5th, 7th, and 8th most frequently charged offenses, respectively. False statements of purchase of a firearm, count 3. Go to false statement related to information. The United States Sentencing Commission also recently analyzed the number of sentencings involving subsection 922G offenses and found that in 2021, the second most utilized charge was 922G3 offense. Indeed, it makes sense that the subsection 922G3 charge is the second most frequently used gun charge against prohibited persons because, quote, drugs and guns are a dangerous combination, end quote. Handling a firearm requires care, caution, and self-control. These qualities are compromised by the psychological, and physiological effects of illegal drug use, including cocaine use. There was also an additional aggravating factor that distinguished Mr. Biden from other defendants who are prosecuted under subsection 922G3 for illegal possession. Mr. Biden lied on a federal form to obtain the gun. That fact is considered aggravating conduct by the United States Sentencing Commission. Third, I consider the deterrent effect of prosecuting Mr. Biden for his gun crimes as the principles of federal prosecution state. Criminal law's goal of deterrence, quote, should be kept in mind, particularly when deciding whether prosecution is warranted for an offense that appears to be relatively minor. Some offenses, although seemingly not of great importance by themselves, if commonly committed, would have a substantial cumulative impact on the community, end quote. I determined that, holding to account a habitual crack cocaine user who lied to purchase a firearm, will promote deterrence. I also consider the deterrence purposes inherited in 18 U.S.C. subsection 922G3, which was enacted to, quote, keep guns out of the hands of presumptively risky people, end quote. Mr. Biden's dangerous possession of the gun while he was using drugs and engaging in drug deals, and while he was in proximity to children, falls squarely within the type of conduct subsection 922G3 was designed to prevent. Fourth, I consider Mr. Biden's culpability. As a Yale-educated lawyer and business person, he understood that he was lying on the background check form he filled out and the consequences of doing so. But he did it anyway because he wanted to own a gun, even though he was actively using crack cocaine. After carefully considering these factors, I determined that they weighed in favor of prosecuting Mr. Biden for the gun offenses. This stuff is good. I like this. The 922G3 is the second most frequently used gun charge against prohibited persons. Which is 3%. That's good. I'd say it's kind of swaying. But I still don't feel like federal gun charges. I feel like there's all kind of stuff. Well, I don't think I mind the taxes being federal, but the gun charges, I feel like they sort of kept them at state. I don't know, maybe, Mr. Biden was charged with the tax and gun offenses in summer 2023. In 2023, before I became special counsel, I determined that there was sufficient evidence to charge the tax and gun offenses. Once I made the determination, the parties began plea negotiations, something that often occurs pre-indictment in criminal cases when the defendant is represented by counsel. The discussions include both felony tax violations, tax evasion violation of 26 U.S.C. subsection 7201, and filing a false return in violation of 26 U.S.C. subsection 7206, and misdemeanor tax violations, willful failure to file, and willful failure to pay in violation of 26 U.S.C. subsection 7203. Mr. Biden had signed agreements in 2021 and 2 that told the statute of limitations as to the tax offenses, and he was thus aware that all of these charges were on the table. The discussions also include potential charges related to Mr. Biden's unlawful possession of a firearm while he was using and addicted to crack cocaine. The plea discussions occurred over several months, and in June 2023, the parties negotiated a potential resolution that did not include all the charges under consideration. This is a common result when plea negotiations occur pre-indictment. The potential resolution was memorialized in two separate agreements. First, the parties agreed to enter into a plea agreement resolving the tax offenses, in which Mr. Biden would plead guilty to 2 counts of willful failure to pay taxes in violation 26 U.S.C. subsection 7203. The plea agreement also required Mr. Biden to admit to a statement of facts, setting forth the conduct underlying both the misdemeanor and felony tax offenses. Second, as to the gun offenses, the parties agreed that Mr. Biden would be charged by information with illegal possession of a firearm. They also conditionally agreed to enter into a diversion agreement. Generally, under a diversion agreement, the defendant agrees to satisfy certain requirements in exchange for the government's promise not to prosecute him for a particular crime. Under the diversion agreement here, Mr. Biden agreed to comply with a number of terms and conditions for a 2-year period, including that he relinquish any firearms, refrain from using drugs and alcohol, and otherwise abide by the law, after which time the United States would agree to dismiss the firearms charge. During this 2-year diversion period, the diversion agreement would have immunized Mr. Biden for any federal crimes encompassed by the statement of facts set forth in the plea agreement, which were related to the tax charges, as well as an additional statement of facts in the diversion agreement that addressed Mr. Biden's conduct with respect to the gun offenses. Specifically, that section stated, the United States agrees not to criminally prosecute Biden outside of the terms of this agreement for any federal crimes encompassed by the attached statement of facts, attachment A, and the statement of facts attaches Exhibit 1 to the memorandum of plea agreement filed the same day. The agreement does not provide any protection against prosecution for any future conduct by Biden or by any of his affiliated businesses. The diversion agreement also contained a dispute resolution procedure. Pursuant to this provision, the United States could seek a determination by the U.S. District Court for the District of Delaware that Mr. Biden had breached his obligations. Upon such a finding, the government could prosecute him for any federal criminal violation of which it had knowledge. On June 20th, 2023, the United States filed in the U.S. District for the District of Delaware a 1-count information charging Mr. Biden with illegally possessing a firearm as a drug user or addict in violation of 18 U.S.C. subsection 922G3, and a 2-count information charging Mr. Biden with failing to pay his income taxes for the 2017 and 18 tax years in violation of 26 U.S.C. subsection 7203. The parties then submitted the proposed agreements to the court. On July 26, 2023, Judge Maylene Noriega, I think that's what you say, held a hearing on the agreements. During the hearing, Judge Noriega, I'll just say Noriega, asked Mr. Biden if he was relying on any promises other than those in the plea agreement. Federal Rule of Criminal Procedure 11B2, which is touted in showing that a plea is voluntary, provides that, quote, before accepting a plea of guilty or nolo contendere, I think that's no loss contestant, the court must address the defendant personally in open court and determine that the plea is voluntary and did not result from force, threats, or promises other than promises in a plea agreement, end quote. If a defendant answers that he is relying on promises outside of a plea agreement, a court must reject the agreement. Mr. Biden and his counsel told Judge Noriega that Mr. Biden was relying on promises outside the plea agreement, and his counsel specifically referenced the separate diversion agreement. However, this contradicted the plain text of the plea agreement, which stated that, quote, any and all promises, representations, and statements made prior to or after this memorandum are null and void and have no effect whatsoever, end quote. The United States raised this provision with Judge Noriega, and she recessed the proceedings to allow the parties to confer. After a brief recess, Mr. Biden's counsel insisted that he was, quote, ready to enter a plea to that plea agreement without contingency, without reservation, and without connection, end quote, to the diversion agreement and its immunity provision. Oh, bit of a mess up by Mr. Biden's counsel there. As the hearing continued, Judge Noriega asked the parties about the immunity provision and the diversion agreement. The United States represented that, under the immunity provision, it cannot bring tax charges based on the conduct set forth in the statement of facts in the plea agreement or firearm charges related to the particular firearm identified in the diversion agreement. Judge Noriega then asked whether the United States could bring unrelated charges, such as those under the Foreign Agents Registration Act, and the United States responded that it could. Mr. Biden's counsel disagreed. The hearing recessed again, and Mr. Biden once again reversed course, with his counsel stating that the immunity provision only covered crimes related to his, quote, gun possession, tax issues, and drug use, end quote. Judge Noreka then focused her questioning on another provision of the diversion agreement, the provision stating that if the United States believed Mr. Biden had breached the agreement, the U.S. District Judge for the District of Columbia could determine whether a breach had occurred. She raised concerns about the court's ruling and overseeing whether the United States could bring additional charges in the event of a breach. At the conclusion of the hearing, Judge Noreka deferred on whether to accept or reject the plea agreement, or whether she had the authority to do either. In response, Mr. Biden elected to plead not guilty to the charges, as was his right. After the hearing, the parties continued to communicate regarding proposed charges to the diversion agreement and plea agreement. On July 26, 2023, Mr. Biden's counsel proposed 3 alternatives to the diversion agreement and plea agreement. First, he suggested changing the plea agreement to a Rule 11C1A agreement, a form of plea agreement that requires approval by the court. Second, he suggested changing the plea agreement to a Rule 11C1C agreement, which would have contained a stipulated sentence. If the court did not accept the sentence, Mr. Biden could withdraw the agreement and proceed to trial on the tax charges. Third, he suggested, quote, redrafting everything, end quote. On July 31st, 2023, the United States made a counter-proposal that revised only the paragraphs about which Judge Noreka had raised questions, specifically removing the provision about immunity of the diversion agreement and inserting into the diversion agreement a mechanism for determining whether a breach occurred that did not involve the court. On August 7, 2023, Mr. Biden rejected the United States proposal. Accordingly, the proposal, plea agreement, and diversion agreement were withdrawn, and the United States informed Judge Noreka of its intention to seek indictments. The revised only the paragraphs removing the provision about immunity and the diversion agreement and signed. So this is basically talking about Biden getting charged, and then the whole plea agreement stuff that were laid out. So it definitely seems like they messed up on the plea agreements. Removing the provision about immunity in the diversion agreement and sending it to the diversion agreement a mechanism for determining whether the breach could. I wonder what they were thinking. I mean, did they think they would win the case? I feel like that'd be the only reason why they wouldn't accept the plea. Because I feel like given the evidence, like he was going to lose. So it's best to do the plea deal, but I'm not sure why they didn't. Unless they really did think that they could win. D. After plea discussions failed, Mr. Biden was indicted for the tax and gun offenses. On September 14, 2023, a grand jury in the District of Delaware returned an indictment charging Mr. Biden with 3 counts. Count 1 charged that Mr. Biden knowingly made a false statement in the purchase of a firearm in violation of 18 U.S.C. subsection 922A6. Count 2 charged that Mr. Biden made a false statement related to information requiring to be kept by a federally licensed firearms dealer in violation of 18 U.S.C. subsection 924A1A. And count 3 charged that Mr. Biden, knowing that he was not lawful user of a controlled substance or addicted to a controlled substance, did knowingly possess a firearm in violation of 18 U.S.C. subsection 922G3. Over the next few months, Mr. Biden filed 4 separate motions to dismiss, including a motion to dismiss based on selective and vindictive prosecution, and they were all rejected. He appealed all 4 of these decisions, and 2 separate, 3-judge panels of the Third Circuit unanimously rejected his claims. Mr. Biden sought en banc review in the Third Circuit and was denied. Accordingly, the case proceeded to trial on June 3rd, 2024. En banc. What was it? 12. Order denying defendant's petition for en banc. Oh. I was hoping they'd tell me what that was. After a 6-day trial, the jury convicted Mr. Biden of all 3 offenses with which he had been charged. Damn, only 6 days. Mr. Biden was scheduled to be sentenced on December 12, 2024. President Biden pardoned his son on December 1st, 2024, and 2 days later, Judge Noreka administratively terminated the case. Separately, on December 7th, 2023, a grand jury in the Central District of California returned an indictment against Mr. Biden for 9 counts, failure to pay taxes for tax years 2016 through 2019 in violation of 26 U.S.C. subsection 7203, counts 1, 2, 4, and 9, failure to file a 2017 Form 1040 and 2018 Form 1040 in violation of 26 U.S.C. subsection 7203, counts 3 and 5, attempting to evade his taxes for tax year 2018 in violation of 26 U.S.C. subsection 7201, count 6, and filing a false 2018 Form 1040 and false 2018 Form 1120 in violation of 26 U.S.C. subsection 7206, count 7 and 8. Like in the gun case, Mr. Biden filed a number of motions to dismiss, 9 total, and again, each one was rejected, including another motion to dismiss for selective and vindictive prosecution. Mr. Biden again appealed these decisions, this time to the Ninth Circuit, and his appeals were again all denied. He also sought en banc review, but he was denied. A jury trial was scheduled for September 5th, 2024. On September 5th, 2024, before jury selection could begin, Mr. Biden informed both the United States and the presiding judge, Judge Mark C. Scorsese, that he intended to change his plea of not guilty to an Alford plea, or a plea in which the defendant maintains his innocence. He did so without having either sought or secured the consent of the United States. The United States told Judge Scorsese that it would oppose an Alford plea, and Judge Scorsese indicated he would follow the procedure in Federal Rule of Criminal Procedure 11A3 for nolo contendere plea, which Judge Scorsese described as an analog to an Alford plea. Under this procedure, Judge Scorsese stated that he would consider the United States position and the public interest before accepting the plea. After a brief recess, Mr. Biden then changed his position and said that he intended to plead open to all the charges in the indictment, meaning that he could choose to plead guilty to all the charges in the indictment without a plea agreement. Why would you do that, though? He could choose to plead guilty to all the charges in the indictment without a plea agreement. That's the whole point of a plea agreement, so you can give it to sentencing. Sentencing was scheduled for December 16, 2024. After Mr. Biden was pardoned on December 1st, 2024, Judge Scorsese terminated proceedings. During the investigation, Alexander Smirnov made false statements to law enforcement agents and was subsequently charged. Yes, finally. Something I want to hear about. In 2020, an individual named Alexander Smirnov, who served as an FBI confidential human source, told an FBI agent that Mr. Biden and his father received $5 million bribe payments from a Burisma executive. These statements were recorded in a Form 1023, an official FBI record. During the investigation of Mr. Biden in July 2023, the FBI requested that the United States Attorney's Office for the District of Delaware investigate Mr. Smirnov's allegations. My team subsequently determined that his allegations were fabricated. Based on February 14, 2024, a grand jury in the Central District of California returned a 2-count indictment against Mr. Smirnov, charging him with making a false statement in violation of 18 U.S.C. subsection 1001, and creating a false and fictitious record in violation of 18 U.S.C. subsection 1519. Investigators also learned that Mr. Smirnov had committed tax crimes and to conceal millions of dollars in income. Damn, that's I forget the word. On November 21st, 2024, a grand jury at the Central District of California returned a 10-count tax indictment against Mr. Smirnov, alleging tax evasion for tax years 2020 through 2022, in violation of 26 U.S.C. subsection 7201, counts 1, 5, and 8, filing a false IRS Form 1040 for tax years 2020 to 2022 on his own behalf and on behalf of his domestic partner, in violation of 26 U.S.C. subsection 7206, counts 2, 3, 6, 7, 9, and 10, and filing a false IRS Form 1120S for tax year 2020 on behalf of Goldman Investments Group in violation of 26 U.S.C. subsection 7206, count 4. Ironic, that's the word. Ironic. Mr. Smirnov pleaded guilty to 4 felony counts on December 16, 2024, including creating a false and fictitious record and 3 counts of tax evasion. Really? Mr. Smirnov was sentenced to 6 years incarceration. He paid full restitution to the IRS in the amount of $675,502. Wait. False and fictitious. What was the other one? No, he wasn't charged with a false statement? I'd go I'm not sure whether they settled for the plea deal or why they settled for his plea. Could have easily gone for the false statement, but he deserved it. Okay. Okay, number 4. The prosecutions of Mr. Biden were not vindictive or selective. Okay. This is the section where you convince me, Mr. Weiss. What time is it? Oh, Jesus. I'm not gonna get done with this, am I? How did I do the indictment so fast? The results obtained in the prosecutions of Mr. Biden confirmed that I faithfully adhere to the principles of federal prosecution. The gun case, a jury of 12 of Mr. Biden's peers, saying in Delaware, his home state, unanimously found him guilty on all charges. In the tax case, by pleading guilty, Mr. Biden admitted that the facts support all the elements of the crimes alleged in the indictment. Not only were both cases proven beyond a reasonable doubt, but they resulted in a verdict lawfully rendered by a jury and an admission of guilt. In making my decisions, I remained impervious to political influence at all times. However, Mr. Biden and his counsel have continuously accused me of vindictively and selectively prosecuting him, and in the press release accompanying his son's pardon, President Biden echoed these claims, saying that he believed Mr. Biden was, quote, selectively and unfairly prosecuted, end quote. These baseless accusations have no merit, and repeating them threaten the integrity of the justice system as a whole. 8 different Article 3 judges appointed by 6 different presidents, including Mr. Biden's father, considered and rejected Mr. Biden's claims that these prosecutions only came because of political pressure from congressional Republicans. Indeed, 2 district courts held that Mr. Biden had not identified any evidence that he was being selectively or vindictively prosecuted. Judge Garza stated that there were, quote, no facts indicating that the government undertook charging decisions in any respect because of public statements by politicians, let alone based on defendants' familial and political affiliations, end quote. Judge Norveka likewise held that Mr. Biden offered, quote, nothing credible to suggest that the conduct of Republican lawmakers or anyone else had any impact whatsoever on the special counsel, end quote. Judge Norveka explained, to the extent that defense claims that he is being selectively prosecuted rests solely on him being the son of the same president, that claim is belied by the facts. The executive branch that charged the defendant is headed by that same president, defense father. The Attorney General heading the DOJ was appointed by and reports to the defense father, and the Attorney General appointed the special counsel who made the charging decision in this case. While the defense father was still the same president, Defense claim is effectively that his own father targeted him for being his son, a claim that is nonsensical under the facts here. I disagree with that. Regardless of whether congressional Republicans attempted to influence the executive branch, there's no evidence that they were successful in doing so, and in any event, the executive branch prosecuting the defendant was at all relevant times and still was headed by defense father. I don't like that statement. Defense claim is effectively that his own father targeted him for being his son. The implication is that Joe Biden, can effectively tell the DOJ who to prosecute when that hasn't been the president's role. The president has never done that kind of thing. So I don't agree with that at all. I don't know how I feel about that statement. I don't like that. That feels icky. In rejecting Mr. Biden's argument that he was selectively prosecuted because the United States was no longer pursuing the diversion agreement, Judge Norveka wrote, the problem with this argument is that the charging decision at issue was made during this administration by Special Counsel Weiss at a time when the head of the executive branch prosecuting the defendant is defense father. Defendant has offered nothing credible to support a finding that anyone who played a role in the decision to abandon pretrial diversion and move forward with indictment here harbored any animus towards defendant. End quote. Yeah. I still don't like this whole when his father headed the executive branch. I don't like that. Judge Norveka also recognized that in this case there were, quote, legitimate considerations that support the decision to prosecute, end quote, including the fact that the, quote, government has an interest in deterring criminal conduct that poses danger to public safety, end quote. In sum, the president's statements squarely contradict the findings of the federal judges presiding over both of Mr. Biden's cases. Moreover, throughout this prosecution, President Biden and his spokesperson have repeatedly and emphatically asserted that the prosecution, quote, has been done in an independent way by the Department of Justice, end quote, that the president would, quote, abide by the jury's decision, end quote, and that he would not pardon his son. These remarks stand in stark contrast to the president's recent assertion that the jury's verdict of Mr. Biden's admission of guilt amounted to a, quote, miscarriage of justice, end quote. Only after Ms. Biden's guilt had been fully and fairly adjudicated did the president claim that this prosecution was the result of, quote, raw politics, end quote, and that, quote, no reasonable person who looks at the facts of Hunter's cases can reach any other conclusion than Hunter was singled out only because he is my son, end quote. Politicians who attack the decision of career prosecutors as politically motivated when they disagree with the outcome of the case undermine the public's confidence in our criminal justice system. The president's statements unfairly impugn the integrity not only of Department of Justice personnel, but all of the public servants making these difficult decisions in good faith, as Judge Scorsese stated in the response to these remarks. Quote, the president's own attorney general and Department of Justice personnel oversaw the investigation leading to the charges, and the president's estimation of this legion of federal civil servants, the undersigned include or unreasonable people, end quote. The president's characterizations are incorrect based on the facts on this case, and, on a more fundamental level, they are wrong. Okay. How many? Oh. Okay. 5. Additional charging decisions. President Biden had chosen to issue a, quote, full and unconditional pardon, end quote, for Mr. Biden covering, quote, those offenses against the United States which he has committed or may have committed or taken part in during the period from January 1st, 2014 through December 1st, 2024, including but not limited to all offenses charged or prosecuted, including any that have resulted in convictions, by Special Counsel David C. Weiss and docket number 123-0-00061- MN in the United States District Court for the District of Delaware, and docket number 223-CR-00599-MCS-1 in the United States District Court for the Central District of California. Accordingly, I cannot make any, end quote. Accordingly, I cannot make any additional charging decisions as to Mr. Biden's conduct during that time period. It would be inappropriate to discuss whether additional charges are warranted. I feel like that would already be discussed, but Appendix A, Indictment, United States v. Robert Hunter Biden, 223-CR-00599-MCS, Central District of California, December 7, 2023. Do I want to read the indictment? I don't agree. No, I don't disagree with the facts laid out in the case. So, I don't think I'll read the indictment. Because this isn't what I disagree with. So, we'll probably just skip the indictment. How much of this is the indictment? Where's the A? Where's the... Here we go. Okay. Motion to dismiss, don't kill. Notice of pardon, don't kill. Indictment, that's the other one. the motion to dismiss. Alexander Smirnov indictment. I mean, I don't disagree with the Biden indictment itself. I just disagree for why it happened. Smirnov, I don't think we need to look at the indictment for that. I don't care about the tax stuff, and the false statements are obvious. So I think that this is what we needed to read. So, yeah. I think I am kind of swayed towards it not being as vindictive. I guess I just have to look at how much the Republican stuff influenced the beginning of the investigation, like the start of it. Like the House Republicans and all the hearings and stuff. I guess I'd have to look into how much, if at all, that influenced the beginning of the investigation. That would kind of determine my opinion on this. But, yeah. I guess now for the fun stuff. Yippee. Jack Smith time. So, watch the next video if you want to see actual fun stuff about J6 and all the ways our federal government failed us to put a criminal in jail who tried to overthrow our democracy and take control of the government via insurrection. So, I guess, see ya.